Good evening, everyone. My name is Jim Wabandato. I'm a program officer at the Indian Land Tenure Foundation. Tonight, we're having a town hall on appraisals. The town halls is a format that I had been working with and working to develop to help us reach landowners during COVID pandemic. And I think it still poses a very good opportunity to bring information to people who may not be able to travel to our events and gives us a much broader reach. The purpose behind these town halls are to tackle important issues to landowners on ownership and management issues of Indian lands, and to bring together land professionals. In this case, we've got appraisers. Last month we had attorneys talking about wills and estate planning, but to bring together professionals and give them so that they can be accessible to Indian landowners to answer their questions and help illuminate different issues. Tonight we've got three wonderful guests with strong appraisal backgrounds. I'll introduce them in alphabetical order. Dave Baker, who is an appraiser in South Dakota. Terry Leibel is also an appraiser in South Dakota, and Gregory Powell. He is with the Appraisal and Valuation Services Office. He's currently located in Albuquerque. Is that correct, Greg?
Phoenix. I'm in Phoenix.
Southwest. Okay. As we kind of move into the topic, I wanted to take an opportunity to highlight that this is a monthly feature. Next month's town hall will be on July 27th, and it will address the probate process. Some quick house cleaning. What I'll ask is unless you're asking a question, or in our case, presenting specific information to address a question, I'll ask you to mute your microphone, your computer, your telephone, so as to not pull away from what the speaker is sharing. Also, questions can be submitted directly through the chat feature. I will be monitoring that and bringing them into the conversation. If you did choose or would like to directly ask a question, still put something into the chat to let me know that that is something you're interested in doing, and we should be able to make it so that you can directly ask your question of our experts. Having said that, like I said, I introduced the guests in alphabetical order, but I'll kind of throw it out to Dave to start and let Terry and Gregory kind of pick up after that, and who would like to introduce themselves tonight. Thank you.
I'm Dave Baker. I've been appraising for a lot of years. I've appraised for about 30 years on Indian reservations, mainly in the Great Plains region, but I've also done appraisals in other areas, all types. So right now I'm a fee appraiser and primarily working in South Dakota and North Dakota.
I guess I'm up then. My name's Terry Leibel. I'm an independent fee appraiser here in South Dakota. I've been doing appraisals in one way or the other for about 30 years. I've done in my past life as a residential appraiser. I do mostly ag appraising now, but when I was doing residential appraisals, I completed appraisals of homes on tribal trust lands in 7 of the 9 reservations in South Dakota. So I have quite a bit of experience at that matter. So I'm glad to be here today. Thank you.
Hi, my name's Greg Powell. I'm the regional supervisory appraiser here in Phoenix, and I have oversight of the appraisal programs for the Department of Interior across 4 different regions. I've got responsibility for the Southwest region, which is New Mexico and Colorado, the Navajo Nation region, the western region, which is Arizona, Nevada, Utah, and parts of California, and then the Pacific region, which is the remainder of California. I've been with the federal government in this capacity here in Phoenix for the last 5 years. Prior to that, I had been in Billings, Montana, doing appraisal work for, at that time, the Office of Appraisal Services, which was located in part of the Office of the Special Trustee. Prior to that, my experience with appraisal industry had been in the Denver metro area. I was a fee appraiser working with my father-in-law, and we valued rural properties all across Wyoming, Colorado. We got into Nebraska a couple of times, dropped down into New Mexico various times. So very broad range of appraisal experience. And since I've been with the federal government, I've done appraisal work, be it appraisals themselves or reviews across all of the western states, except for Oregon and Washington. So broad range of experience, in Indian trust properties, and thrilled to be here tonight and happy to answer whatever questions that I can answer.
Wonderful, thank you. I appreciate the introductions. I'll start off with some fairly basic questions to get the process started. And again, as we get chat questions or other things coming through, I'll throw that in front of you guys. I would recommend that you guys kind of jump in where you see appropriate to answer the questions. The first question I'll ask is, can you describe, I see the term valuation used even in the federal name for the office now, appraisal. Is there really a difference in those words and those concepts? And as Indian landowners, agricultural producers, what should we take away from the difference when people use the terms valuation versus appraisal, appraisal report? I mean, those are things that get thrown around quite a bit.
From the federal government's perspective and from our agency's perspective, the reason that we include both terms in our name, Appraisal and Valuation Services Office, reflects the nature of the work that we do. Our work involves appraising the surface interests as well as valuing the subsurface interests that are involved. And our agency is composed of 3 divisions: the Federal Land Division, the Division of Mineral Evaluation, and then the Indian Trust Property Valuation Division. Those 3 divisions each offer a different service. Obviously, the first one, the Federal Lands Division, they're responsible for valuing and appraising all of the various federal projects that come along for the Department of Interior, whether it's Fish and Wildlife Service, Bureau of Land Management, National Park Service, Bureau of Reclamation. Each of those represents different teams within the Federal Lands Division, and those are generally appraisals of the surface interests with a mineral component that's performed by the Division of Mineral Evaluation. When we get into the Indian Trust Property Valuation Division, we are often asked to value both the surface and the mineral interest. And our staffs generally do not have experience valuing, appraising the mineral values. And so we rely on our counterparts within the Division of Mineral Evaluation to provide us a sense of those values so that we can appropriately incorporate those values into our appraisals and make a true fee land appraisal of that property. So in terms of, is there a difference between the 2 terms? Technically, yes, but in practical matters and in everyday usage, there's not very much difference. And from our standpoint, if you say, hey, I need a value, we will assume that you're asking for an appraisal and move forward based on that accordingly. Like I said, there's technically a difference. An appraisal has a very clearly defined meaning, Valuation has a different meaning, but in terms of practical day-to-day differences, it's very minimal.
So Terry or Dave, did you guys have anything extra to add to that? Or shall we look at the next question?
Well, I guess I would briefly state that this is an interesting topic here in South Dakota. This last year, through the legislature, they basically, prior to the legislative session, they opened it up to have evaluations that could be completed by anyone. Meaning that you didn't need a license or certification or anything as an appraiser to do an evaluation. The appraisal industry decided that there's probably, especially on the residential side of it, going to be some, some people that will try to get evaluations done by someone that's not necessarily an expert, because again, you don't need a license to do evaluations. So to put it on an even basis, there are some appraisers in the state, and I think some will do that. But anyway, to get on an even basis, we thought, well, it would be good if appraisers could do evaluations. So long story short, anybody could do evaluations in the state except appraisers, because it was under the guise, doing an evaluation was under the guise of doing an appraisal. So in other words, if we had a license, we really couldn't do evaluations. So to be on an even basis with everybody else, non-licensed, legislation was passed last year that appraisers can do evaluations. And of course, it has to be specified that as an evaluation and not an appraisal. I don't think, in essence, in reality, I think very few appraisers will actually do evaluations, but at least now they can do evaluations if they wish to. So anyway, just thought I'd throw that in. That's what's happened in South Dakota just the last few months, last session. So
Thank you, Terry. That I'm sure will be helpful to some of our audience. And again, this is being recorded, so we don't know from where people will get and use this information.
Just to add, after hearing what Terry said, it's, I think, an important note to folks that they understand when Indian trust property is valued, the Code of Federal Regulations sets forth certain specific manners in which it can be valued. There's generally within the regulations three approaches or three methods, I should say, to value Indian trust property, regardless of whether it's surface or subsurface or both. Those three methodologies are an appraisal as defined by the Uniform Standards of Professional Appraisal Practice, USPAP, a market study, or the third one is any other method determined by the secretary. And in that case, it would be some methodology approved by the director of AVSO and routed up through the upper tiers of the department for approval. Those three methods are what we have to do. We can't do, and we can't call a valuation an evaluation. We have to call it an appraisal. It has to abide with the appraisal standards set forth in USPAP. So if you're wanting a value on a property not located on Indian trust property, that evaluation that Terry mentioned may be perfectly acceptable. But if you're needing a valuation done on Indian trust property, it has to fall within the guidelines of the regulations.
Thank you, Greg. Looking at a couple of questions here. I think based on that, one of our audience members is wondering which land transactions in Indian country will require an appraisal?
That's a great question. Just about any type of transaction on Indian trust property will require an appraisal. If you want to sell your interest to any other party, it will require an appraisal or a market study or some other methodology, one of those three things that are recognized by the CFRs. If you want to lease your land, if you need to get a right of way across your land for some reason, or somebody wants one, if you're trying to sell it, if there's a probate case, I can't think of a transaction where one is not needed. There may be situations where the appraisal could be waived, but the regulations say it's still needed. And so in those cases where it could be waived, the BIA, the Bureau, would come to the landowner and say, in order for us to process this, you've got to get an appraisal. And if the applicant at that point chooses to, then they can say, well, I'm going to waive it because I meet the various criteria. And for different transactions, the criteria differs, but it generally requires 100% of the owners saying, yes, we're okay waiving an appraisal, and we're just going to accept the value that's provided by whoever is requesting it, whether it's a lease, whether it's a sale transaction, or whatever the situation might be. And that differs from tribal land pretty significantly, because tribes have the ability to waive the valuation on tribal land that the individual landowners don't have. The federal government, for whatever reason, gave tribes more leeway that way than they did the individual landowners. And so tribes can waive the valuation, individual landowners can't, unless they meet certain requirements that are set forth in the CFRs.
As a follow-on to that, are there differences in the process when land is appraised for different kinds of projects? So when we're talking about pretty much all land transactions, are there differences between appraisals for probate versus rights of way versus sales and so forth?
Interestingly, yes, there are. And the biggest difference comes in from the standpoint of what the Code of Federal Regulations provides as a definition of value for any given transaction. For example, for a lease, it has a very specific definition of value. For a right-of-way, it has a very specific definition of value. And that's the expectation that we would see and we would appraise the property to, is that definition of value provided in the CFR. Not all of the transactions have their own definition of value in the CFR, though. And in those cases, for example, for a sale or for probate, there is no defined value. It's not set forth in the CFR. And so we have to make some assumptions as to what that value definition is, and we would use something that we think is appropriate at that point. So in terms of what the difference is, that would be the first difference, the definition of value. And then it gets into, for rights of way, there's other things that the CFR says we should consider. It doesn't say that we have to include them, but we need to consider them. And that would be things like going rates, throughput values, things of that nature that may appear on some rights of way, but not necessarily all rights of way. And so those become something that the appraiser has to be aware of. They can't just go in and make an assumption that the way they've always done an appraisal will work in this case, because it is rather unique and it is different, and they do need to be aware of those differences. So yeah, there are some differences. I won't say it's case by case, but it's appraisal type to appraisal type. I'm sure, I know Dave has tons more experience than I do, so I would certainly be interested in hearing his thoughts on that, and Terry as well.
Well, yes, I agree with what you're saying. Each appraisal, when an appraiser accepts an assignment, he's trying to solve a valuation problem. And it depends on the definition that that appraiser uses on how he goes about solving that problem or coming up with the value of the property. The definition used in a right-of-way is not the same definition that's used in a typical market value appraisal where somebody wants to sell their land or transfer their ownership. Also, the definition may be slightly different if you're working for a bank. If you're doing a valuation for a loan, the definition might be slightly different depending on what the bank wants. So you can't just assume, I agree with Craig on that, you can't just assume the definition of the value that you're looking at is going to be the same in every case.
Terry, did you want to add anything, or are you good? You're on mute, by the way.
I certainly don't think I can improve on anything Greg and Dave said. I think they summed it up good.
Okay. So I'm trying to think of how to best do this. Otherwise, one of the questions I had during registration was, can normal appraisals be done on trust land, or can only BIA appraisals be done? So in other words, I think what they're trying to get at is, it seems like there's a difference between a standard appraisal for non-Indian projects, but then Indian projects or properties have a whole different setup. Can you guys address that?
I guess I could start. The difference is land ownership. Generally speaking, on non-Indian land, everything is pretty much fee simple. By fee simple, that means that you have all the rights. When you own land, you have all the rights inherent in that ownership. On tribal lands, it typically, on reservations on tribal lands, the majority of it is trust land. It's tribal trust land. And because it's on tribal trust land, a couple decades ago, they came out with the HUD 184 Indian lending program through HUD, and the FHA manual, because there are, and I'm just talking about South Dakota here because that's all I'm familiar with. In the state of South Dakota, there may be some actual market sales of residential properties, but nobody tracks them. They're impossible to track. So in essence, the sales comparison approach, which is the primary method used on appraising fee simple home ownership, does not work for homes on tribal trust lands in South Dakota. So the HUD 184 Indian lending program specifically states, in lieu of sales, to do the sales comparison approach, you can use other approaches to value, which brings us to the cost approach. And basically the cost approach means, what is the cost new of that structure? Even though the structure might not be new, what is the cost new of that structure? And then you minus any physical, functional, or economic depreciation and obsolescence. So in other words, if a home is, say, 20 years old, first you start off with what is the cost new, if you had to build it today, minus the depreciation, obsolescence, because it is 20 years old. And onto that, you add the value of the land. Or I'm sorry, you don't add the value of the land because it's on tribal land. So basically, the cost approach is used pretty much solely in the state of South Dakota to do home appraisals for lending, for lending purposes of any homes on tribal trust land, just because there are no sales. So I hope that sort of answers that question.
I think that definitely helps quite a bit. Again, people are coming at this with different levels of expertise. And so I think, again, having all three of you guys available brings different perspectives to the issue, so that I think at the end, everyone will have a better understanding.
If I can just piggyback briefly on what Terry was saying, I think, I know for me, I didn't come to this realization until just a couple of years ago, but the department does not get involved in the valuation of homes on Indian land. We don't do any mortgages. That's all handled by others, whether it's appraisers, fee appraisers like Terry and Dave, who then submit that paperwork to HUD or to farm, to Department of Agriculture under the Farm Home Administration programs that way, or whatever other program there might exist, but the department doesn't handle any of that. And so if you have questions about how to value homes and what does that look like for Indian properties, I have to just make sure everybody understands right now, Terry and Dave are the experts there. I am not even a newbie in that. I know nothing when it comes to that. So
One thing I would like to add is ABSO, the Bureau of Indian Affairs, and the federal government, they're interested in what is the value of the trust asset. And the trust asset is land. So they're concerned with the transfer of land. They want to make sure that the seller is receiving fair value for his ownership interest. Buildings, houses, commercial buildings on trust land are not considered trust assets. So ABSO, the federal government, and BIA are not involved in that aspect of the valuation at all, because they're not considered trust assets.
good clarification, Dave. Thank you.
Let's see here. How long should parties to a trust appraisal, or blanking on the term now, Oklahoma has a lot of it, restricted fee lands, yes. So for trust and restricted fee lands, how long should parties expect an appraisal to take? And once that appraisal is in hand, how long is that good for?
It's good until the values change, is the correct answer. At one time, values were changing substantially a few years back every 6 months. So the appraisal is only going to be good for about 6 months. If you've got a period where land values are not changing drastically from one period to another, the appraisal might be good for a year. There is no set time on how long an appraisal lasts. It's the value indicated in the appraisal will be valid until the land values change. That's my standard answer.
To kind of
That's
piggyback,
generally what. Go ahead, Terry.
I was just going to say, to kind of piggyback on what David's saying, if it's lending, and that's specifically, my experience was with lending. If it's lending, it's it's more or less, there's no specific set guidelines that I know of on how long an appraisal will be accepted for a value on any home. I understand it's pretty much up to the lending institution. So, you know, you have, you know, different lending institutions look at it differently. However, I think the industry more or less, and you know, I'm sure that Greg knows this better than I do, but in lending, I think the industry pretty much, from what I've seen, is up to 6 months. So in other words, if you did an appraisal and it's only 6 months old, or maybe a little older than 6 months, I've never seen anybody, in my experience, any lending institution accept an appraisal that's over a year old. So basically, it seems like that 6 months to a year, most lending institutions will say, hey, we need an update of the original appraisal or a new appraisal, but I don't think there's any specific set guidelines. So
yeah, that's accurate from the department's standpoint as well. It's been probably 4, maybe 5 years ago, I had posed that same question to our solicitor's office in DC, and basically their response was, is it a current value? And they were of the opinion that if it's a couple of years old, that doesn't represent current value, even though the value may not have changed. They want a current value opinion. And so defining, well, what is a current value opinion becomes really tricky too. We get that question from superintendents out at the BIA agencies on a frequent basis. Can we continue to use this appraisal? It's been 6 months, or it's been a year, or it's been a year and a half. And our response is exactly what Dave and Terry have said. You know, if the values have changed, then we can't urge you to, we can't recommend that it be used. We would, you know, suggest that you request a new appraisal. So that kind of segues then into the second part of your question of how long does it take to get an appraisal done, you know, in these situations, or to get a transaction approved. It can take quite a while. The more complex the transaction, the longer it can take. And for some of the commercial leases that we run into down here in the Southwest, it's not uncommon to see those transactions take 2 or 3 years from start to finish. And if the applicant comes in at the front end and requests the appraisal, which they often do, just so that they have a sense of feasibility, and then they get to the tail end of the project and need it to be submitted to the BIA for approval, that appraisal may be too old to be of any use anymore. And so they need to get it redone. And so that would slow down the process a little bit more at that point then too. So all of those different things can come into play, and it's something that people just have to be aware of. You know, it's not that we do it by design, it's just the way that it is, I guess.
Okay, to follow with that, one of the questions I had from registration said that the land buyback appraisals seem to be done rather quickly. So how are they done, and how reliable were the appraisal reports for the land buyback program?
The land buyback program uses a different approach to getting their appraisals done. They use what's called a mass appraisal. And a mass appraisal is a statistical methodology of collecting volumes and volumes and volumes of sales information, and analyzing each one of those sales for all the various components, running it through statistical software, and then in turn plugging in each of the subject property characteristics and having the computer then spit out a value for each of those subject properties. It appears like it can be very quick, but in reality, there are months and months and months of work on the back end of that people don't get to see, that can really make it quite slow if they're starting fresh for the first time on a reservation. It's not uncommon for those to take up to 6 or 8 months for them to gather all the data, do all of the analysis. Once they get all of that done, hitting the button so it starts spitting out values, yes, that's very quick, and that's often what people see in terms of how quickly it turns around. If they're going back and revisiting a reservation that they've done in the past, it's most of the legwork and the back end work has been done previously, and so now they're looking for additional sales to add to that data set, and that can go much quicker than an original appraisal did. But yeah, it's a different tool altogether. It's a different animal altogether. In terms of the accuracy, Ms. Iris Chrisman, the director of the Land Buyback Valuation Program, is very firm in her belief that it is completely accurate and entirely appropriate.
Thank you, Greg. I've got a couple more questions that kind of cover the basics, and then we'll be able to dive into some of the more complex questions that people had. Succinctly, do gift deeds require an appraisal?
It's been a while since I've looked at the CFR for that, so I don't know off the top of my head.
Dave, were you going to say something?
Yeah, I didn't hear the question.
Oh, do gift deeds require an appraisal?
No. I'm opposed to that, but right now, unless the superintendent of the agency requests one, we've never done gift deed appraisals. What we used to do back in late 80s and early 90s was we did essentially used a market study to indicate the approximate value of an ownership interest, a fractionated ownership interest. And then that translated into no, we're not going to do gift deed appraisals. I think it's a mistake because when I was working for the BIA, doing appraisals for the BIA, we had several individuals that were going to gift their ownership interest in some property to their grandson until they found out approximately what it was worth, and then they changed their mind. My philosophy is the federal government has a fiduciary responsibility to protect the trust interest of that individual. And by allowing them to gift interest without full knowledge of what the value is, I think is a violation of that fiduciary responsibility. The way it sits now, the answer is no. They don't appraise trust interest or gift deeds. But I think that's a mistake. That's my opinion.
Okay, thank you.
And
we appreciate that.
Jim, I think, and I was just trying to look at the CFRs to see if I could find it real quick, and I wasn't able to, but I think, and don't hold me to this, but I think that the CFR gives a provision for an appraisal if one is requested. It may not be required, but if one of the parties requests it, it will be done. Having said that, I can only think of one example where we've done a gift deed appraisal in-house, and that was again a situation kind of like what Dave was talking about. That the party that was doing the gifting had agreed with their I believe it was a sibling at the time to make this gift deed, and once they started to think that maybe the value was other than what they'd been led to believe, they requested an appraisal, and it completely changed whether or not they went ahead with that transaction. But I don't think it's required. It is an option, though. If I if I find it, or when I find, I'll go back and look when we're done with this. I'll let you know, and you can get the word out to folks through your channels appropriately, Jim.
You're
muted,
muted,
Jim.
Jim.
Thank you, guys. That gives me a good reason to pause and remind everybody that if there are questions that we don't have answers to, between our three experts, we should be able to track that down and get the information shared. If there are other things that come up, we will certainly make sure that that information also becomes available to our audience. Last kind of more simplistic question is, who determines the highest and best use in the appraisal process? And can the requester or the landowner provide input into that? So who determines the highest and best use when doing an appraisal?
I'll take a stab at that. It's the appraiser. The appraiser, there's 4 tests involved in a highest and best use analysis. One, is the proposed use physically possible? Is it legally permissible? Is it financially feasible? And is the prospective use maximally productive? Those 4 tests go from a lot to one finite use. Can the landowner assist the appraiser in determining the highest and best use? Yeah. And that's why appraisers meet with the landowner and ask a bunch of questions in order for the appraiser to determine what the highest and best use of that property is. Simple answer, the appraiser determines the highest and best use.
And just to piggyback on that, it is required, Dave did an excellent job of surmising it, and it is required by USPAP. USPAP stands for the Uniform Standards of Professional Appraisal Practice. And those federal guidelines state that the appraiser must, in all cases, appraise property at its highest and best use.
Greg, did you have anything, or shall we move on?
Yep, let's move on. Those guys did an excellent job with that.
Thank
Nothing
you.
to add.
So I'm going to shift gears, as I said, into questions that are going to be more specific to issues that landowners or land users encounter. What types of issues are addressed on agricultural projects or properties as opposed to many other transactions for Indian land?
Not sure that I understand what that question is asking, Jim.
For some of our landowners and some of our land users, agricultural activity is an important aspect. So what are some of the issues that would be covered under valuation and appraisal of agricultural projects or agricultural properties, as opposed to just say a standard lease, right-of-way, or other type of transaction? I mean, are we looking at, number of heads of cattle that can be grazed? Are we looking at, AUMs, as that's shortened to? What are some of the issues that you guys have seen in valuing and doing appraisal reports for agricultural projects?
Well, it actually depends on the property. Some common elements you look at is productivity. If you're looking at grassland, livestock water, access is important in some cases. If you've got timber on the property, does that have any value? There's a midrib of factors that appraisers look at when they're valuing agricultural property. In some areas, a factor may be important, but you go 200 miles away and maybe that factor is not important. To give you an example, one thing I found on agricultural property is in areas where you don't have rural water, sometimes stock dams or wells are important consideration. As soon as rural water comes in, stock dams and wells become less important. So they may not have the impact on value that they did before the rural water system came in. This is just an example. It's not always 100%. Topography might be a problem. Some lenders are very concerned about access on agricultural land in Indian country because of lack of established public rights of way. So some lenders are very concerned about that, and they may not make a loan because of the lack of a public access. So other lenders may not be concerned with that. So there's all kinds of different factors that come in when you're looking at agricultural property versus a commercial property or a residential property, that type of thing. There's no standard factor that is present in every agricultural property.
Yeah, add to that list that Dave mentioned, fencing. Fencing is important in some places and not at all in other places. If the property is irrigated, is it flood irrigated? Is it sprinkler irrigated? If it's sprinkler irrigated, is it side roll? Is it center pivot? Is it wiper pivot? Is it, how's it irrigated? Does it have drainage? Does it need drainage? Is that drainage provided by tiling? You get all of those kinds of factors coming into play and have to be considered. And like Dave said, they're very often local in nature, and you have to have that geographical competency that we hear about from time to time in order to understand whether those factors are significant in that particular area. One that I ran into recently down here in Arizona, out at Yuma, because they're the vegetable capital of the United States for winter vegetables. The restrictions on stray animals that can get into those vegetable patches can destroy a crop, and so the tenant farmer has to go to extra lengths to fence out stray animals. Otherwise, he stands to lose his entire crop. And that even goes to bird droppings and some of those kinds of things. So it's all very localized and very, very important to understand, but very localized.
Greg brought up stray animals. One factor in western South Dakota is prairie dogs. Now, a small acreage that's infested with prairie dogs may not have an effect, but I've seen 3,000-4,000 acres infested with prairie dogs. And what happens when you research the market is there's a substantial drop in value because the prairie dogs eat all the grass. There's nothing left for the livestock. So somebody buying a seriously infested prairie dog tract is going to discount that. It doesn't affect the small towns, but as the towns get bigger, you might see an effect from prairie dogs.
Again, thank you. Let's see here. We've got a few questions about structures. So let me kind of scroll through here. prior question was, how do I value a home on trust land where the structure, the house is a depreciating asset? Another similar question was, let me see, whether or not buildings are considered trust assets. It was felt that that was dependent on specific tribes and the terms by which the land went into trust for the tribe. So the American Indian Probate Reform Act for most tribal communities changed the status of attached structures, and therefore it has an impact on value. Wondering what you guys can say about that for our audience.
Well, occasionally I was asked to appraise the structure as well as the land, which the superintendent wanted that, so that's what I did. But that's a rare situation. For probate, that might be a different cat. I don't know. I haven't done any probate appraisals of trust land. I could see the judge wanting an indication of the value of a house or something that's being probated. I could understand that. But generally, I haven't participated in any recent appraisals of probate property of trust land. So I'll turn it over to Greg on that.
Yeah, we haven't had any probate requests come through where a building was part of the probate. It's for all of the probate stuff that I have seen through the offices that I represent. It has only been the land. It hasn't been any buildings. Not to say that that wouldn't happen and couldn't happen. I haven't seen it. We have, not related to probate, but through a tribal request, we have valued some buildings. But that was due to the tribe specifically requesting the building valuation. But outside of that, it's really rare for my office, for any of our offices, to get a building valuation request under any circumstance.
Well, when I was employed with the BIA as an appraiser, I did two sets of buildings on two different appraisal requests that were requested by the BIA. And that's over a period of 30 years. So it's not common to appraise buildings along with the trust land.
And is that a result of the American Indian Probate Reform Act change, or was that prior to that as well?
That was prior to that. I've done land for probate on trust land, but I haven't done anything that's included buildings. Since the APRA came in, I just haven't done any. So.
And I probably should clarify, because when I mentioned the American Indian Probate Reform Act, or APRA for short, it does kind of focus the conversation on probate issues, but the change was universal, and it separated permanent structures from being considered trust assets. So that has had a cascade effect into all sorts of activities, including leasing and other home ownership, agricultural activities. So I just wanted to make sure for our audience that I'm clarifying that, you know, APRA as a probate law has had a much larger impact because of that technical amendment from 2008. Let me see. How do, like I said, this is another question. How do appraisers take the passage of time into account when an appraisal is meant to be used engaging historical projects or perhaps specifically in litigation?
We recently completed an appraisal for the Department of Justice for a trespass case where the tenant who had been leasing Indian land hadn't been paying their rent for years and years and years and years and years. I think 93 was the last time that particular tenant had paid rent. The statutes, the federal statutes that govern trespass only allow damages to go back 6 years and 90 days. So what my staff that completed that appraisal had to do is they had to go back, you know, at this point in time, 7 years ago now, and look for that historical data to develop their appraisal so that they could accurately capture that trespass rent for that time period back 6 years and 90 days. So that's one example. We don't get a lot of those requests from the Department of Justice. The Bureau will send in requests from time to time trying to get a negotiated settlement so that it doesn't have to go to Department of Justice. And in those cases, we might see a much longer time frame. But again, we still have to go back and try to find historical data that's appropriate and can be used to develop those values back, you know, historically. I'm not sure if that's covering and answering the question quite like you're wanting it to, Jim. If I'm missing the mark here, let me know and I'll refocus that and think a little bit more.
Oh, I think that did address quite a bit. Litigation has been an issue when dealing with trespass and with other activities. I think you provided a good introduction. I think if people have other questions, it probably is going to be much more specific to their circumstances. And so I believe that it gave a pretty good broad stroke so that people understand what some of those topics or issues might be when looking at valuations and appraisals during a litigious activity.
Okay.
Dave or Terry, do you have anything to add about appraisals, passage of time, especially when they come to litigation?
Well, other than historical appraisals, one of the things an appraiser routinely does, regardless of the type of appraisal they're doing, is they look at sales maybe a year or two ago, depends on how many sales you have available in an area. And you analyze the data. Here's a sale that occurred a month ago, and here's a sale that occurred 2 years ago. Is there a difference in value as a result of time? There might be a difference in value for any number of different factors, but you're trying to see if there's a change as a result of the passage of time. And it's not the same for every area. Some areas might see a slight increase or an increase in value in grassland. Other areas might see a decrease in value in grassland over a year or two. So you can't just assume just because this area showed an increase and you're moving to another area that increase is going to be effective there. It depends on your sales that you have, and you analyze those sales to see if there's an adjustment warranted just for time. And so that's a common factor, whether you're doing a right-of-way appraisal or a residential appraisal or a commercial appraisal. every appraiser looks at, is there effect due to the passage of time?
Greg and Dave did a phenomenal job of summarizing that again. The only thing I could add is that I do a lot of ag appraising for estates and, estate planning in estates. And those are always done as the date of death. So when somebody calls me about an estate, I ask them, when was the date of death? And if they say, a few months ago or last year, well, that's one thing. And I think the most dramatic one I had was, it was 18 years prior to me doing the appraisal. So doing a retroactive appraisal from 18 years ago. Most of the states I appraised in about 20 some different counties in the state of South Dakota. And the one county that actually had sales back that far was the one that I was appraising in. So I just lucked out that they actually had sales information from 17, 18 years ago. But basically, just like Dave said, summed it up, it's about the market. Whatever the market is today is not going to tell you what the market was a year ago, 2 years ago, or 10 years ago. You have to get that historical data and try to figure it out. And in that case, when you go back that far in one appraisal, I even used several different methods. One trying to find what limited sales there was, another trying to use the assessed values, and then the ratio between the assessed values and the sales at that time, and the assessed values and the sales at this time, et cetera. So it gets tricky. It gets somewhat a little more complex trying to figure out a value retroactive appraisal, especially if a lot of years have gone by. So,
Well, we have
I
reached, I was gonna say, we reached the end.
I didn't do this appraisal. There was another appraiser that was involved in it. And it was a class action lawsuit up in New York. And it was a federal class action lawsuit. And his assignment was to come up with the land value every year from 1776 to present. And this would have been in the late 90s. And so he spent months, and he actually found sales that occurred in 1776. Now, he couldn't verify them because there was nobody around at that time, but he found documentation of sales. They were few and far between, but he was eventually able to come up with a value every year for this 60,000 acre tract from 1776 to the late 90s. So you can imagine the work he put into that, just figuring out what the time adjustment was.
Well, I want to thank.
Out of 5 appraisers, he was the only one left standing by the time it hit the Supreme Court. So it was an interesting job.
Thank you. I do want to say that we've reached the end of the hour, but we still have a few. I'm going to take advantage of our 3 guests. And there are going to be other questions we didn't get to. I'll email the 3 of you with some of that, and then I can reach back to the individuals who requested those. But if you could take about a minute each and kind of give us your parting thoughts on appraisals, the appraisal process, Indian lands. And I'll start with Greg, since he got stuck at the end last time, at the beginning.
Put me on the spot. Closing thoughts. Wow, that's to me, the job that we have as appraisers of Indian trust properties is one of the most important and yet one of the most overlooked jobs by the department. I fear that the department doesn't, as a whole, understand the significance and the importance that the appraisal process has for Indians and for the lands that they own. People rely on us and what we do every day for their livelihoods, for their wealth, for their families, everything. And I fear that the department doesn't fully grasp that at times. I'm hopeful that with the new secretary that will begin to change. We'll see. But in terms of parting thoughts, that is it for me. I know how important what we do is every day to people's lives. And I can only hope that the department shares that same sense of gravity and importance.
Appraisals in Indian country is everything. Every transaction, in one way or another, the government requires an appraisal. And there's no way around it. If you want to sell your interest in a piece of property or trade your interest in a piece of property, the government's involved. There's going to be an appraisal involved. There's certain transactions that the government is not involved in, and one of them could be a mortgage that doesn't involve a transfer of ownership. It seems to me that AVSO doesn't even review those. So the lenders are willing to refinance or take a mortgage on property that doesn't involve a transfer of ownership. There is a problem if the lender or if the seller or the buyer applies for a loan to buy an interest in trust property, then the problem arises in that AVSO becomes the sole client of the appraiser. This is causing a problem with lenders. They won't take a loan or make a loan in Indian country if they can't have a say and see that appraisal. And I recently did a lender appraisal for a sale, and the only way the lender would get involved in that sale is the seller had to apply an appraisal review waiver. And he approached 3 lenders, and none of them would take him except this one government lender said, we'll do it, but because of AVSO requirements, the seller has to sign an appraisal review waiver or we won't do it. And that's one thing I wanted to bring up on this is some of the appraisal requirements by AVSO is affecting Indian country. And I'm glad Greg is here, so I got somebody to talk to about it. And that's all I have to say.
And that's probably a very big issue. I don't think we can tackle everything that concerns Indian country about appraisals tonight. So I know appraisals will come back in the future. But you raised a very good point, Dave. And excuse me, Terry, for maybe giving Greg, if he has a 30-second rebuttal or comment.
No, but I'll reach out to Dave individually and see if we can't figure out exactly kind of what was going on in that situation, because it doesn't fit with what I understand the process should be in that situation. So it may be that there's opportunity for us as AVSO, as a government agency, to learn something new. We don't have all the answers. We don't know everything. And if we are open to listen, we can often learn something new. So I'd be more than happy to visit with Dave one-on-one about it and see what I can understand better.
Sounds good.
Thank you, Terry. Parting thoughts?
Yeah, just real briefly. Again, what I've done, my experience is appraising homes on, residential homes for lending, specifically in South Dakota and some in North Dakota. Basically, I know a lot of people, and I think there was a question before asking about the time to get an appraisal done. I don't know if that was about mortgage lending or not. I'm going to assume maybe it is. The reason I'm saying that is because being an appraiser for lending purposes in South Dakota and North Dakota, it has been a huge issue on getting timely appraisals done due to the lack of appraisers that are willing to go on a reservation to do them on trust land. Primarily, it's the whole thing is doing them on trust land because, again, if you're doing them on fee simple land, you can use the sales comparison approach. If you're doing them on trust land, again, the HUD 184 Indian lending program specifically states that you can use a cost approach. So we do only the cost approach on trust lands. And if you got 100 appraisers in a room and you tell them, in the appraisal business, we're trained sales comparison, comparable sales. That's ingrained in our brain. So if you tell 100 appraisers in a room that forget the comparable sales, you're going to do cost approach only. Okay, 95 are going to run screaming into the night the other direction because they know that's illegal. You can't do that, right? Well, of course it is legal. That's why they have the HUD 184 Indian lending program. It's been a very tough thing for us to get more appraisers. I don't do them anymore. And there's the South Dakota Native Home Ownership Coalition came into being in the last couple of years to get more home ownership going on the reservation in the state of South Dakota, and to try to break those barriers of what we're barring Native American people to get home, to own homes on a reservation. And that is basically lending. And one of the things in the lending process is getting appraisers to do the appraisals. So we actually did a seminar, the Home Ownership Coalition, of which I'm a part of. We did a seminar last fall, getting appraisers and training a couple of us appraisers, trying to train other appraisers. This is what you can do. This is how you do appraisals on tribal lands, just trying to get them more attuned to wanting to do those types of appraisals and realizing that that is an acceptable method through the HUD program. So anyway, that's all I wanted to say. Thank you.
Again, thank you to Terry, to Greg, and to Dave for sharing their expertise with us this evening. I can tell that appraisals is, I know in other conversations as well, that appraisals is a very confusing issue. It seems to some to be straightforward, but there are complex issues that get involved. So we look going forward, I would hope to get more information into landowners and ag producers' hands so that they can take care of the business. Again, thank you, everyone.
One thing I'd like to mention is, I think about 2 years ago, ILTF had a message runner, and they dedicated several issues to appraisals. And I think you should reissue that again, because it answered a lot of questions we're talking about now. And it was the message runner that you guys generally put out.
Now you said reissue, Dave, you mean to make it available or to update it?
Well, I don't think it needs updating, because the questions that were responded to in that message runner are still, you're asking the same questions now. So I think it should just be reprinted and sent out again.
To follow up on that, I did provide a link to an online version, a PDF capable document of that message runner. So that is a good point. For those who may not have seen the original link to the information and reading materials, the Indian Land Tenure Foundation does have a very good publication dealing with the basics of appraisal. So again, thank you, everyone. I'm going to stop recording.